Hello everyone, I'm Claudia Nadh, Assistant Professor, Soundarya College of Law, and today we are going to be dealing with a topic under the law of torts called nuisance. This is a synopsis. First, we're going to be dealing with the meaning and definition of the word nuisance. The definitions are given by Birmingham and Salmon. Then we will move on to the essential elements of nuisance, the classification or kinds of nuisance, which are private nuisance and public nuisance, the defenses to nuisance, and the remedies therein, after which we would conclude. So let's take a look at the meaning and definition. The word nuisance is traced to be derived from the word nuire, which is a French word which means to annoy or hurt. So now, having understood the root of the word nuisance, let's also analyze two definitions which are given by Birmingham and Salmon. Birmingham says that nuisance is an unlawful interference with a person's use and enjoyment of land or of some right over or in connection with it. So he makes it very clear that the interference must be unlawful and it should be in connection with the use and enjoyment of land or some right or connection with land. Moving on to Salmon's definition. Salmon says that the wrong of nuisance consists in causing or allowing without any lawful justification the escape of any deleterious thing. Okay, deleterious things means anything that can cause harm or damage. Okay, so the escape of any deleterious thing from his land or from elsewhere into land in possession of the plaintiff. Example, it can be water, fumes, smoke, gas, noise, heat, vibration, electricity, disease, germs, and even animals. Okay, so Salmon has widened the scope of the word nuisance. He says that anything you allow to escape without any lawful justification, and the thing that is escaping should be deleterious. That means it should be harmful, and it can be in the form of water, fumes, smoke, so on and so forth. So, to simplify this further, let me give you an illustration. Just imagine that I am setting up a cement factory adjacent to your house. There is smoke, there are dust particles, fumes, everything that is entering into your houses. So now, here is a scenario when, without any lawful justification, I am allowing the escape of smoke, gas, noise, whatever said and done, okay, even vibration, okay, I'm letting this deleterious thing escape from my land and it is causing you a trouble, okay, then we call it as nuisance. Having understood this, let's move to the next slide. What is the essential element of a nuisance? In other words, what is the ingredient of nuisance? How can you say that yes, this is actionable under law of torts under the heading nuisance? So all these three parameters should be met to call it as an essential element of nuisance. So let's take a look at it one by one. The first one is wrongful act by the defendant. Second one is damage, loss, or inconvenience caused to the plaintiff. So here we have to read these 2 points together. It should be a wrongful act done by the defendant. No doubt about it. Okay? And this wrongful act should cause a damage, loss, or inconvenience to the plaintiff. Okay, so that must be very clear. Next one is the concept of de minimis non curat lex, which means that law shall not consider minimal damage. That means law will not consider trivial issues. There are two case laws to explain this maxim. Ushaben versus Bhagilakshmi Chitra Mandir. Okay, this case is famous because it's got to do with the screening of a movie called Jai Santoshima. So the plaintiff felt that screening of this movie is definitely hurting the religious sentiments of a particular Hindu community. Okay, but the court dismissed the plea, stating that it's up to the plaintiff to watch the movie or not. So they consider it as a very minimal damage. So if it is a minimal damage, it is definitely not an essential element of nuisance. Okay, let's take a look at the next case law. Halsey versus ESO Petroleum Company Limited. In this case law, excuse me, in this case law, there was an emission of smokes from factory which is polluting the environment. Okay, and because the plaintiff had a particular sensitivity to this particular pollution coming from the factory, he had health issues. So the court held that yes, the factory is liable to the extent of it polluting the environment. Okay, but on the other hand, it is not accountable to the extra sensitivity which the plaintiff has. Okay, that aspect of it, they considered it to be a minimal sort of a damage. So it was not considered under the elements of nuisance. I hope both these case laws are clear. Now we know that uh, nuisance is classified into private and public. So first we will try to understand what is private nuisance, and then we will also do what is public nuisance, and all this we will be doing through case law expositions so that you will understand what is a private nuisance, what is not a private nuisance, what is public nuisance, and what is not a public nuisance. After which we will compare and contrast what is private and public. That is the difference between both private nuisance and public nuisance. Okay, so let's get going. Private nuisance. So here's this case law, Sturgis versus Bridgman. Okay, this case law actually tells us that if suppose a particular region has a nuisance, okay, it does not mean that the same thing will cause nuisance in every other place. Okay, example, if suppose there is a rice mill in one particular area, it does not mean that every other place this rice mill being established is a nuisance. It will depend on the facts and circumstances of each case. Okay, next case law, Christine versus Davy. Here, the plaintiff is actually giving music lessons. And whenever the plaintiff is giving music lessons, the defendant would make furniture and crockery noises, okay, from his house. Crockery is like plates. With plates and furnitures, he would make a lot of noises, because of which it was interrupting the music lessons. And here, it was considered as a private nuisance, and the plaintiff said that the defendant should be restrained from doing this hereafter. Okay, next case law, Hollywood Silver Fox Farm Limited versus Emmett. In this case law, the plaintiffs were a set of people who were actually breeding silver fox, okay, silver foxes. And what happened is, because Emmett was actually making a lot of noise, intentionally making noise to disturb the breeding. And the court considered this and said that yes, an injunction have to be granted because it's very evident that the defendants are trying to disturb the breeding. Okay, next case law. Andrak versus Self-Regent Company. Okay, so in this case law, there was unreasonable demolition and construction of buildings. Okay, I would like to tell you that the next two case law, Andrak's case law and Webb case law, it is regarding construction of buildings, and Helen's case law and Dilware case law, it is related to trees. Okay, so let's get going. If you notice the word unreasonable demolition and construction of buildings, okay, so it's not like you can hold every building construction responsible. Only something which is unreasonable you can hold responsible. Okay, here there was a hotel, and because of this unreasonable construction and demolition of building, there was a lot of noise and dust which interrupted the business of the hotel. Here, damages were granted because it was considered as private nuisance. Okay, next case law, Webb versus Barker. Here, then again, building construction was carried out in the night. Okay, so injunction was granted to that effect that they cannot do construction work in the night. Okay, I hope I made myself very clear. Next case law is St. Helens Smelting Company versus Tipping. Here, the fumes from the defendant's factory, okay, was actually damaging the tree of the plaintiff. Here also, it was regarded as a nuisance. Okay. The next case law, Westminster City Council. Okay. In this case, what happened is the roots of the tree, okay, was creating cracks in the adjacent building. Okay, in this scenario also, they were entitled to get some damages. Okay, so I hope you understood the scenarios when private nuisance will be attracted. Let's move on to what is public nuisance. Okay, so there are four case laws which I have chosen. First one, Harold versus Watney. So, in this case, there is a 4-year-old child who was trying to climb a defective fence. Okay, and this happened in a highway. And because it was defective, the child got severely injured, and it was regarded as a public nuisance. Okay, the next case law is very important. It's a landmark judgment, and this can be asked for exams also. So, pay close attention. Soltau versus D held. Okay, here the plaintiff had an issue because the defendant was a priest. Okay, he filed a suit against the defendant who was a priest because the church bell kept ringing day in and day out, and this was causing a lot of irritation. Okay, so the plaintiff was entitled for injunction. Okay, next case law, Dwyer versus Mansfield. This is a very interesting case law because the plaintiff here was uh, a person who had an issue with another shopkeeper who was selling potatoes. Okay, so there was scarcity of potatoes, and because of which, all the people who wanted to buy potatoes went exclusively to his shop, and there was a big queue and commotion. So the other shopkeepers felt that this was disrupting their business. So here the court held that no, injunction to that extent cannot be granted because potatoes are also sold out to the public. So it is definitely not a public nuisance. Okay, so they couldn't actually corner this person. Next case law, Attorney General versus PYA queries. So here it is important to note that even vibrations also can be a nuisance. Okay, it's not just dust or smoke or fumes. It's not just that, even vibrations. So vibrations from the defendant's estate, okay, was causing problems to the plaintiff, and they considered this to be a public nuisance, and damages were granted accordingly. Okay, Moving on to the key differences between what is private nuisance and what is public nuisance. Pay very close attention to this. To sue in private nuisance, one must have an interest in land. I repeat, to sue in private nuisance, one must have an interest in land, but no such interest is necessary in public nuisance. Why? Because in public nuisance, it is for public at large. So you don't need to establish that connection or interest to a particular land. Okay. Second point, private nuisance is firmly rooted in the protection of landholding rights, whereas public nuisance represents an unsuccessful attempt to link the criminal law with compensation for damages. So it's not possible to link something which is of a criminal law to just a mere compensatory or damage oriented one. Okay, it's supposed to be unsuccessful. Why? Because whenever it is a public nuisance, it will take the color of a crime. Okay, then IPC will also be attracted. So keep this in mind. Now, we will be curious to know what are the defenses to nuisance. Okay, there are three defenses. The first one is prescription, second one is statutory authority, third one, which you've already dealt with, de minimum non curat lex. You remember those two case laws which I had given at the beginning? Okay, so I'm not going to be doing that. The other two, I will be taking it up. So, what is prescription? It is very clear that Section 26 of Limitations Act and Section 15 of the Eastman's Act have elaborated the fact that if suppose you are enjoying a particular right for 20 years, okay, later somebody cannot come and claim nuisance, okay, because this person has been prescribing to that particular role for a period of 20 years. So that becomes a defense to nuisance. So in this case, Eliotson versus Feetham. Okay, here the excuse me, here they were carrying out a noisome trade. Now, what is the meaning of noisome trade? Noisome here does not mean noise. Okay, it is a trade in which there's a lot of foul smell and stench involved. Okay, but this person has been carrying out this trade for the past 20 years, because of which it was not regarded as nuisance. It was a perfect defense for nuisance, and this person was permitted to continue this noisome trade. Next case law is Mohini Mohan versus Kashinath Roy. Here there was singing of kirtans and bhajans. Okay, so they were doing it for a very long time. Okay, but permission was not granted to them. Okay, but the court said that if this would have had a customary color to it, if this was a part of the customs, then definitely it would be granted. Otherwise, it becomes a defense to nuisance. Okay. Next case law is Vaughan versus Staff Railway. This is regarding statutory authority. Okay. Let me give you a simple example. We have a railway line which is just somewhere close by to our house. There is noise coming from the railway. Can we say nuisance? We cannot, because, or if suppose they are setting up some railways, they are doing it based on statutory authority. So it becomes a defense to nuisance. Okay? Now, remedies for nuisance. This is very easy and very important also. There are three remedies: damages, injunction, and abatement. Damages will be in the form of monetary benefit or materialistic compensation. Okay, and if it is not possible to pay them in money or give them some material, then they would opt for injunction. Injunction is when you're restraining someone from doing something, okay, be it temporary or permanent, depending on the facts and circumstances of each case. Now, abatement is when the defendant himself feels that he is at wrong, okay, even before the courts could intervene, they can pitch in and say that, yeah, this is what is causing nuisance, I will stop doing this on their own voluntarily. That is called as abatement. Okay, so these are the three remedies of nuisance. So it's very clear to us that we learned the definition, the meaning, then we understood the elements of nuisance, the kinds of nuisance which is private and public, the differences between them, defenses to it, and remedies. Okay, with this I conclude. Thank you.